Good morning, everyone. Now I'd like to introduce our today's speaker. Sujit Ghosh is a senior advocate based in New Delhi, India, specializing in tax law, constitutional law, and electricity law. A graduate of the National Law School of India, University, Bangalore, Sir has 29 years of professional experience. He started his career as a tax consultant at Arthur Andersen and later Ernst & Young, where he developed his expertise in indirect tax, sales tax, VAT, excise duty, customs, and FT. He also co-founded BMR Advisors as a tax consulting firm. After enrolling as an advocate with the Bar Council of Delhi in 2010, Sujit Sir transitioned into tax litigation. He founded BMR Legal, focusing on indirect tax disputes and court representations. In 2013, he established Advaita Legal, growing it into a boutique tax litigation firm with over 80 lawyers. Sir left Advaita Legal in 2019 to establish Chambers of Sujit Ghosh, where he operated as an independent arguing counsel. In this role, he handled major tax, regulatory, and electricity cases before the Supreme Court, High Courts, and various tribunals. He has appeared as lead counsel in significant cases across the Honorable Supreme Court of India, various High Courts, and the tribunals such as SESTAT and Appellate Tribunal for Electricity. His work spans a wide range of indirect taxation matters, including GST, excise, and VAT, customs and trade laws, as well as regulatory issues under the electricity law and the foreign trade policy. Apart from his litigation practice, he is committed to pro bono work, frequently providing educational services to tax professionals and engaging in classroom teaching for High Court judges through the National Judicial Academy. He is also involved in a pro bono case before the Delhi High Court on behalf of National Judicial Academy. On January 19, 2024, Sir was designated as a senior advocate by the Supreme Court of India, a prestigious recognition of his contributions to legal practice. With his designation, he has now moved into counsel practice, focusing on high-level court appearances and advocacy, leaving behind his chamber practice. Thank you, sir. Now, may I request sir to take up the session.
Trying to interpret a judgment. Now, the moment it becomes interpretation of a judgment, then we are getting into the thickets of subjective satisfaction of each individual of how he or she would like to read it, and particularly the revenue officer's reading of the law. So if nothing else, this judgment, my immediate reaction is it leaves a huge floodgates opened for interpreting the judgment itself and therefore further litigation. I think that's the unfortunate outcome of this particular judgment, because there are crevices in which many things will fall. There are places where there is a doubtful interpretation of a particular word, and I'm happy, but certainly not very happy with the judgment. I'm happy because there is some ray of hope that the Supreme Court has given to the taxpayer community. But then I'm not happy because it leaves many things to be interpreted by the down the line tax officers and then appeal courts and tribunals and high court, etc. So the first message I want to give you is this is not all. This is not all. This is probably the beginning of something that we will have another 3-4 years down the line. I also understand that the revenue is planning to file a review petition. Well, they may have good reasons to do that. I don't know whether any taxpayer is planning to file a review petition or not. But should such a review petition actually get accepted, then we are looking at re-examining the whole structure once again as and when such a review happens. So that's my opening remark about, or the caveat I wanted to put, that whatever you're going to hear is my personal interpretation of the judgment. If there's anybody in this room who has a different view of the matter, more than happy to hear that, more than happy to appreciate that. But don't take my view as the only view, because I don't have the authority of law to put a stamp to my interpretation because I'm not a judge. And therefore, all of us are equally entitled to have our views. And the whole idea about this kind of webinar is to cross-pollinate our ideas. So what you will hear from me is my personal view of the matter, and that is how I would like to place it. There is no right or wrong view in that sense. That's one. Second point I want to make caveat is I'm assuming that all those people, I don't know, Arup, how many people are there? 480 or 450?
We have got more than 500 registrations as
We
of
have
today.
500 now.
Yeah.
Okay, so I'm hoping that all the 500 learned participants have read the judgment, and therefore I don't have to go into the basics of what the controversy, how the controversy emanated. So I'm going to stick to the core points rather than talk about basics. If there is anybody, however, who wants to understand the basics, please drop a message. We'll see if I can, in the process of my conversation, I can deal with that. So
I would just like to take 1 second. I would just like to share that there are many tax administrators also in the audience today.
oh, very well.
So we are happy to have some senior tax revenue authorities also. They're really
Very well.
and glad that they also join.
Very
Apart from
good.
many senior people from the industry also.
Very
Apart
well.
from senior. Really
So
happy.
my opening remarks would be a food for thought for the revenue officers, because that actually means that they have a handle now available to relook at how they would like to interpret. So it's going to be beneficial for them as well. So now coming to the judgment. So we know that the validity part of section 17.5 C and D has been rejected by the court. Now, if you ask me, was it a good justification for rejecting that validity point? My personal view is the Supreme Court has taken the most hackneyed approach to judicial review of a tax legislation. Hackneyed approach is like the run-of-the-mill approach, saying that I'm not going to get into the classification, distortion, and discrimination, etc., because legislature or the revenue has a very wide latitude. Unfortunate that it is that repeated propositions before the Supreme Court on validity of some of the GST provisions have been met with a fatal blow. We saw that when it came to VKC. We saw that when it came to Mohit Minerals. Of course, Mohit Mineral, there was a, while the entire judgment was pro-revenue or pro-government, the one last line of composite supply, we succeeded. We saw the same fate in Safari. The point I'm trying to make is that increasingly, it has become very clear that whenever you're mounting a challenge on Article 14, so far as GST legislations are concerned, the chances of your success is next to none. So as you advise your clients, as you advise your businesses, keep that thing in mind as a factor to be considered in evaluating whether or not you should challenge under 14. That's the first one. Now, that's one aspect of that. The second aspect is that the mistake that many times lawyers who draft petitions make is that they only make the company a party. When you make company a party, then your relief available is only under Article 14. Because Article 14 applies to any person. But if you really want to invoke Article 19(1)(g), which is available only to a citizen, you will have to and you must include one of the shareholders or directors of the company as a co-petitioner. And if you read Safari, the Supreme Court says that not many people did argue about 19(1)(g). There wasn't any substantial arguments. And the reason why substantial arguments were probably not made was any senior counsel who is standing before the Supreme Court will not pursue 19(1)(g) when the petitioner is a company. That's a genuine handicap available to any lawyer who is arguing before the Supreme Court, that 19(1)(g) cannot be pursued by a company. It has to be pursued by a citizen. For all we know, if 19(1)(g) was to be pursued, the argument of reasonable restriction to my business point could have been agitated more effectively. And unfortunately, that was not the case because everybody was baying for the Article 14 argument and not necessarily 19(1)(g). So that's the second point I wanted to make on the validity part. As a best practice, whenever you are doing a 14 and 19 plea before the court, you must necessarily have the company or the petitioner and one of the shareholders. Otherwise, your ability to argue 19(1)(g) will fail. We saw that in VKC also. 19(1)(g) was roughly, vaguely argued, not given much consideration. And in Safari, for sure, there is one paragraph where Justice Oka makes it in 19(1)(g), not many people did argue substantially, whatever it is. The third attribute on the validity part, and I am personally not very happy with that outcome because I was one of those lawyers who was leading the charge on the validity part. So for those of you who don't know, it is not me who argued this plant or machinery plant and machinery. The credit should go only and only to Mr. Datar. What I'm trying to do is probably interpret the judgment, but I have no skin in the game. I never had any contribution on that and or argument. So it's entirely Mr. Datar and his team of lawyers who kind of persuaded the court to think in that line. But the aspect that I was leading the charge was on the validity part on 14, and that submission has not been dealt with at all. And I wanted to spend two or 3 minutes on that because it may be relevant should in some other matter the issue comes back before the Supreme Court. The argument that I had pleaded before the Supreme Court was that, if you look at the definition of works contract service, which is sought to be denied under 17(5)(c), the question of immovable character of the deliverable is wholly relevant. The reason is, insofar as fastening of the tax liability on the contractor who creates immovable property, there is a deeming fiction in the statute which says this will be deemed to be supply of service. Is it not? Schedule 2, sub entry 6 says that works contract shall be deemed to be a service. Composite supply includes works contract, and works contract definition is only about immovable property. So when supply of works contract service is a service deemed fiction, then the factor of it leading to creation of an immovable property is wholly irrelevant, because what is being supplied in the eyes of law de jure is a service. It is not a case where immovable property has been supplied. De facto, it may be immovable property, but de jure what has been supplied is a service. And if that be the case, in the hands of the supplier, it is deemed to be a supply of service. Then in the hands of the receiver, it could not have been treated as a procurement of an immovable property. Because yin and yang, if the supply is of computer, then the receipt is also of a computer. If the supply is of a Pepsi bottle, then the receipt is also of a Pepsi bottle. If the supply is of a service, then the receipt is also of a service. And therefore, if the supply is of a deemed service, then the receipt is also of a deemed service. So while he has recorded the submission in the opening part of the judgment of de jure versus de facto, but when he deals with the immovable property aspect, when he deals with the validity aspect, he starts with the assumption that what has been supplied is an immovable property. And immovable property is a class by itself as compared to a movable property. And that is why he said that there is a reasonable classification, etc. But before he started with an immovable property, it was necessary for the Supreme Court to deal with the submission on de jure de facto immovable property. And to that extent, I think my personal view is that the conclusion on the validity has passed what is called sub silentio. Because without ascertaining whether the subject matter of the controversy is immovable property or not, or the aspect that what has been supplied is de jure services, maybe de facto immovable property, but de jure services, the Supreme Court ought not to have started with the assumption that what is in hand is an immovable property. And therefore, it's a classic case where the judgment has passed sub silentio and therefore warrants a relook. But that is what it is. Maybe in some other matter, when it comes to the Supreme Court, one may make a plea, and it gets very difficult for another division bench to get into the nuances of this restrictive interpretation, etc., etc. Because long arguments were made on what is the purpose of a deeming fiction, that when you deem something as a service, then it has to be taken to its logical conclusion. Logical conclusion means that in the hands of the supplier, it's a service, in the hands of the receiver, it has to also be services. Otherwise, it looks very weird that for taxation purposes, you're deeming it to be a service and you're levying tax. But for credit purposes, you're saying that no, it's the immovable property outside the ken of the GST legislation. That is as weird as it gets, as oppressive as it gets, as unreasonable as it gets. But well, their lordships did not either they did not consider that argument appropriate, or for sure they have not even dealt with it in the finding that there is no discussion on this de jure de facto aspect. So that's the point on the validity part. But I guess that is the thing of the past. Unless a fresh matter comes, we can't probably re-agitate the whole issue. Certainly not before the High Court, because High Court is not going to reappreciate Supreme Court decision and try to say that we are not going to buy that Supreme Court decision on that, because ultimately it's a 141 that will apply, right, wrong, etc. High Courts don't have any power to kind of say that the judgment is per curiam or the judgment has passed sub silentio. So that's it on the validity part. Now we'll come straight to the meat of the matter, which is this whole dispute or discussion on plant machinery, plant or machinery. And I guess once again, I gave credit to Mr. Datar and his team for developing this argument. So what has the Supreme Court said? Simply put, 17.5D has been decompressed, stating that there are two exceptions. First exception is if it is plant or machinery, the restriction on 17.5D does not apply to you. Please keep this in mind. If it is a plant or machinery, the restriction under 17.5D does not apply to you. The sequitur of that is, so long as it is a plant or machinery, even if those may be immovable property, you will still get the credit. That's the proposition one. That's the exception one. The second exception in the decompression of the provision, they said that the second exception is if it is for own account, you will not get it. In other words, the sequitur is if it is not on own account, then you will get it. So the simple golden thread is that identify whether what is getting constituted or constructed is a plant or machinery as per how Supreme Court has interpreted those two words. I'll come to that a little later. If you are able to identify and you fit the basket of plant or machinery, then really speaking, you don't even have to go into 17.5D or its explanations. You're completely, the bracketed portion completely takes you out of the non-obstante clause, and you're as good as sitting in section 16. That's the first reading of the judgment. Assuming for a moment you don't fit into the bracketed portion. In other words, you don't qualify as a plant or you don't qualify as a machine. Then the only way you can come out of it is if you're able to show that it is not on your own account. So what is on your own account? I'll explain. Supreme Court has explained. I'll reiterate and explain that later. So whenever you're sitting on a drawing board or whenever you're looking at your specific fact pattern, or you may be in the Commission of Appeals, or you may be relooking at your whole issue, dissect your problem into two parts. Examine whether you qualify as a plant or machinery. without taking resort to the explanation. Explanation is not relevant to you at all for 17.5D. And also identify whether you are doing it on your own account or not. If the answer is you're doing it is a plant, then you don't have to look at anything else. You are straight away into section 16. If you don't fall as a plant or machinery, then you check whether it is on own account or not. And if you are not on own account, then you are again out of 17.5D, you are straight away into section 16. And these two baskets is on an edifice that what has happened is an immutable property. Because creation of an immutable property is a sine qua non for section 17.5D. I'll deal with 17.5C later. In other words, if in your fact pattern, what seemingly is, it may appear to be fastened to the earth, but if it does not qualify as an immutable property, then 17.5D is not relevant to you to begin with. Then the explanation and everything else that is there in 17.5D is not relevant to you begin with, because the condition precedent for 17.5D is that creation of an immutable property. Now, what is an immutable property? Standard tests will have to be applied. That will depend on the facts and circumstances of the case. So to put it once again in a context, when you look at your fact pattern, the first test you will apply, has it led to creation of an immutable property? If the answer is no, then you stop there. 17.5D does not harm you, you go straight away to section 16. But if the answer is yes, it creates immutable property, then you test what kind of immutable property is it? Is it plant or machinery? Without taking resort to the explanation. If the answer is yes, it is a plant or machinery, then you're again out of 17.5D and go straight away to section 16. But if the answer is no, it is not a plant or machinery, then the third test you will apply. Is it on own account or not? If the answer is yes, it is on own account, then you're stuck. But if the answer is no, it is not on own account, then you're straight away into section 16. So my reading of the judgment is that for 17.5D, there are three tests that you apply, or three tiers of tests that you will apply. And I'm repeating again for everybody's benefit. Test 1, examine if it is an immutable property. That examination of whether it is an immutable property has to be done on the basis of existing jurisprudence on what is an immutable property. Apply Transfer Property Act, its General Clauses Act, various other things, and enough judgments are there. So test 1 is examine whether it's an immutable property. If by applying the test, you believe it is not an immutable property, then you have credit available under 16. You don't worry about 17.5D. Test 2. Assuming that test 1 fails, it is an immutable property. Test 2 is check whether it is plant or machinery as understood in the jurisprudence, not with reference to the explanation, but as understood in jurisprudence. If you pass the test, then again you're back to section 16. You don't have to worry about 17.5D. Test 3. If you fail test 1 and test 2, then you see whether it is on own account or not. If you fail the test, meaning thereby it is actually on own account, then you are stuck. But if it is not own account, again you come out of 17 and go to 16. So these three-tier test is what I believe all of us need to start applying as and when we start relooking up at our business model or litigation that may be before us. Now the million-dollar question, therefore, is what is plant? What is plant? What is machinery? What is an immutable property? What is on account? These are the three things, because all the three tests are predicated on these three criteria. or these three tests. So immovable property by definition means something that is not movable, right? So to answer whether it is immovable property, you do what is called a deductive analysis, which means you trace what is the movable property and test yourself whether you're movable or not. To understand what is the immovable property, you have to look at what is movable, because immovable property is like anything that is not movable is an immovable property. Similar to services, anything that is not goods is a service. And test of movability. Safari itself records the judgment of solid and concrete. In fact, that paragraph where their lordships have brought it out, give me a minute. Para 47. Can you put it up? Para 47. Yeah. Para 47. I'm asking my colleague Anshika to put it up so that we get a context of this particular issue. I'm reading para 47 for everybody's benefit. There are few decisions relied upon on this aspect. The first is Commissioner of Central Excise Ahmedabad versus Solid and Correct Engineering. The case arose from the demand of duty and penalty under the Central Excise Act. The SSE was manufacturing parts and components for road and civil construction machinery and equipment like asphalt drum, etc. One of the questions examined by the tribunal was whether the plant so manufactured could be treated as goods. The issue before this court was whether setting up an asphalt drum hot mix plant by using duty-paid component amounts to manufacture of excisable goods within the meaning of Excise Act. It is argued before this court that the plants in question did not satisfy the test of marketability and movability. This court referred to the definition of movable property under 336 of the General Clauses Act, which defines movable property as property of every description except immovable property. The same enactment defines immovable property as Section 326, which is an inclusive definition which includes land, benefit to arise out of land and things attached to the earth or permanently fastened to anything attached to the earth. This court considered the definition of expression attached to the earth in Section 3 of the Transfer Property Act. In the facts of the case, it was held that the plant subject matter of the case were not per se immovable property, as the same cannot be said to get attached to the earth. This court applied the movability test by holding that the setting up of the plant itself is not intended to be permanent at a given place. The plant can be removed or is indeed removed after the road construction or repair project is completed. The issue that we were called upon to decide about the meaning of the plant did not arise in this case. In other words, something that seemingly appears to be an immovable property, by application of principle of Transfer Property Act and as interpreted by the Supreme Court, can be a movable property. In this decision, the discussion was with respect to a given asset, but that principle has been applied even in case of other assets of various kinds, Sirpur paper mills, wobble-free operation. If you set up something, screwdriver technology, it is for efficient operation of the superstructure. There is no permanency or intention to have a permanency. All of those takes, several judgments are there, including in the case of telecom towers by the Delhi High Court. Of course, the Bombay High Court has taken a contrarian position, but the Delhi High Court, applying this solid and concrete judgment, has held that telecom towers are movable property. Now look at the interesting aspect. I said there are 3-tier tests. And all this for 17.5D, I also said that explanation has no role to play. But if you look into the explanation, there's a specific exclusion to telecom towers. There's a specific exclusion to telecom towers. Anshika, can you just take us to internal page 47, PDF page 47 of Safari? So the explanation For the purposes of this chapter and chapter 6, the expression plant and machinery means apparatus, equipment, and machinery fixed to earth by foundation of structural support that are used for making outward supply of goods or services of both, and includes such foundation and structural support, but excludes land, building, or any other civil structures, telecom towers, and pipelines laid outside the factory. So, for the purposes of explanation, it appears that the legislature has assumed telecom towers to be something which is not plant or machinery, plant and machinery, right? Though the immediate reaction of anybody, more particularly the revenue, would be it is an express policy decision of the government of India or the legislature to deem telecom towers of whatever kind to be animal property and specifically exclude it. Now, therefore, there will be a conflict between the exclusion in the explanation and the ascertainment of movability test when applied to telecom towers on an independent basis. And this conflict is likely to give rise to some kind of litigation. But my answer would be legislature has not said that telecom towers, whatever of its make, is deemed to be immovable property. There is no deeming fiction on the immovability or immovable character of a telecom tower. All that they have said in an explanation, that because the explanation is seeking to explain what is an immovable property, qua plant and machinery. And it is in that context they have said telecom towers, and the explanation cannot be read in isolation. It has to be read in the context of the provision. Explanation explains the provision. It doesn't overshadow the provision. So if the provision does not apply to movable property, then the explanation, assuming 17.5D explanation were to be applied, 17.5C certainly explanation applies. But both are predicated on immovable property. So if the section does not deal with immovable property, it does not deal with movable property, then the explanation has to be read to mean such of those telecom towers or such of those pipelines which are immovable by nature, by application of the immovability test, even though they may be plant or machinery, they will still get excluded. But it cannot be said that per se, moment you have a pipeline in front of you or the moment you have a telecom tower in front of you, without having tested whether it is a movable property or not, you will always get thrown out of the credit basket. That can't be said. So that's the first point. On to test whether it is a movable property or not a movable property, we apply the general principles of law of under the Transfer Property Act. If by application of the test we become movable property, then we don't even have to worry about anything in 17.5C or 17.5D. Then we come to what is plant or machinery and machinery, etc., etc. Now, what the courts have said that plant and machinery and plant or machinery are not one and the same. Why have they said that? They found that several places plant and machinery is written, several places plant or machinery is there. The draft GST provisions had specifically said plant or machinery, but when the final law came, they made plant and machinery. So therefore, there is a specific legislative intent that can be read in. Third, that, well, it has been there for the longest time. This litigation has been there for 4-5 years. If they wanted, they would have amended it. All those things have gone into it. Personally, I don't buy that. I personally don't buy that. It looks like a legislative drafting error. And this is where I want to break a bad news. My gut feel is, there's something called a doctrine of small repairs. The doctrine of small repairs means that the legislature has a power to make retrospective and retroactive legislation if an unintended result arises of interpreting the provision which the legislature did not intend to. When such a situation arises, then to cure the defect, they make retrospective or retroactive legislations and validate what may have been done in the past. So the chances are this good news of and versus or may be short-lived. I hope it is long-lived. I hope so. But knowing how the government, legislature, policymakers, Ministry of Finance generally look at any form of relief to a taxpayer, they are likely to, get aggressive about it. And probably, so I think either the review is on that basis. If the review fails, maybe then they'll move something in the parliament. We don't know. So the other caution point I want to give is that do not peg all your hopes into this and versus or until the dust has settled, another 3 years, 4 years. So, we saw in income tax, the Vodafone judgment and various other judgments happened. Unintended result, they retrospectively amended it from 1962 or whatever. So they have done that in the past when the courts have held in favor. To undo the court thing, they will always do a validating amendment, etc., etc. But that's a caution point. I hope it doesn't come to that stage, but the chances of it coming to that stage, it cannot be ruled out completely. So what the court has said is plant and machinery in the bracketed portion in 17.5D is not the same as plant or machinery in 17.5C. In other words, the explanation attaches itself to 17.5C and certainly not to 17.5D. The explanation is wholly irrelevant and of no consequences for 17.5D. Then we get on to what is a plant or what is a machinery. Plant and machinery. All right. So 17.5D uses the word plant or machinery, right? Now, when they look at the meaning of the word plant, they have, or the judges have kind of got persuaded by principles of law applicable in income tax. But I don't know whether that was the right approach, because it is a basic principle that the Supreme Court also endorses, that expressions used in a given statute cannot be borrowed into another statute unless it is a cognate statute. While you can say income tax and GST is a cognate statute, they're dealing with tax laws, but that may not be strictly true, because the reason why plant was interpreted by the Supreme Court in income tax matters was because it had a very inclusive definition. There was a definition nonetheless. There was a definition of plant under income tax for the longest time. It was in an inclusive manner. It had some representative items sitting in there. It is only in that context that the word plant got interpreted, whereas in GST, plant is not even defined. So how far was it correct on the part of Supreme Court to embody and borrow the entire jurisprudence of income tax into GST? Questionable. But we are not here to question the wisdom of Supreme Court unless a similar matter comes up before them. Right now, it is under 141 law of the land, and we better toe the line. Therefore, the fact of the matter is, today, no matter how high and mighty we may believe intellectually, fact is plant or machinery for 17.5D has to be understood in the context of income tax and income tax alone. That too restricted to two judgments. Of those two judgments, the important judgment that has turned the fate of Safari is the judgment of Karnataka Power Corporation. So he starts with Taj Mahal Hotels, then goes to Anand Theatre, then traces to Karnataka Power Corporation. And what he has done is very strange. Karnataka Power Corporation made a departure from Anand Theatres. Because in Anand Theatre, there was a restricted meaning that was given, which was essentially that, look, if it is something which is going to be housing your business, if it merely shelters the business and has no other purpose, then it is not a building, right? And they say that if it is used for running of a hotel and cinema, they said it is not a plant. Anand Theatres lays down these two very cardinal principles. A, that if it merely shelters the business and has no other function, it is not a building. And the building used for running of a hotel or a cinema is not a plant. In Karnataka Power Corporation, they said that Anand Theatre cannot be given such a wide meaning. And that is where they said, look at the technical specification. Look at whether for generation of power, the paraphernalia of evacuation, etc., all the assets that are required are integrally connected or not. And therefore, that building that houses all of those should be treated as a plant. So what has Supreme Court done in Safari? They have said, because Karnataka Power Corporation says, theatres, we are not dealing with theatres, we are not dealing with, what is that other word, hotels. So what does Supreme Court say in Safari? Other than theatres and cinema, anything else will be plant if it meets with the functionality test. I see no reason, and with greatest respect to the learned judges of Supreme Court, I see no reason why the exception to theatres and cinemas made in Anand Theatre, which was carved out in Karnataka Power Corporation, had to be bodily lifted into GST. Because Karnataka Power Corporation was dealing with a specific set of facts. They didn't want to disturb Anand Theatre. And they say that to that extent, we are not troubled because Anand Theatres made an exclusion to theatres and cinemas only. We are not concerned with that. We are making a sharp departure by saying that, no, in this particular case, functional test is made or technical specification test is made, and therefore it is a plant. And what does the Supreme Court say in Safari? They are marrying the two. The exception of theatre and cinema has been adopted, and the exception of functionality test has been adopted. With greatest respect, I don't see any jurisprudence that has been laid by Safari judgment by the Supreme Court other than application of the existing jurisprudence to a completely different legislation, which we did not even have the definition of plant. And that, to my mind, with greatest respect, wasn't the correct way, but it is 141 and we better toe the line. So today, for something to qualify as a plant for GST purposes, first test, you apply the ordinary meaning in commercial parlance. Now, ordinary meaning in commercial parlance is a very subjective thing. There are no objective criteria to ascertain what is the ordinary meaning and what is the commercial parlance, because commercial parlance could change depending upon what kind of commerce we are dealing with. And even to establish commercial parlance test or ordinary understanding test, history has shown us that it takes a lot of labor. And the labor is essentially going to be in terms of how you have projected yourself in the marketplace, in your website, how your customers perceive it, how the competition in the space or the sphere where you operate, how do they perceive it? So commercial parlance test, which is a well-set test under sales tax, enough jurisprudence on that will come in handy for you to come to a conclusion in your particular fact pattern, whether in ordinary parlance it will be treated as a plant or not. Chilling plant, ordinary parlance, it is a plant. Air conditioning plant, ordinary parlance, it's a plant. Okay. Many plants are there. I mean, you attach a word plant that you have been using for the longest time, probably it meets the ordinary parlance test. Okay. So that's the first test. Nebulous, doubtful, but the tests exist. Jurisprudence exists to test it against this common parlance test or ordinary parlance test or commercial parlance test. That's one. Second test Supreme Court contemplates is the functionality test. While it doesn't explain in so many words in great detail what functionality tests ought to mean, but there is enough jurisprudence to assist us. In fact, functionality test has been laid out under central excise. And there is another test which goes hand in hand and which I would encourage you all to apply is the commercial expediency test attached to that. While the Supreme Court has not spoken about the commercial expediency test, but to make your point stronger, you can, in addition to functionality test, also establish a commercial expediency test. So let me first explain what is functionality test. Then I'll explain to you what is a commercial expediency test. Now, functionality test, the first judgment, Manshika, can you put up Maruti Suzuki? So this judgment of central excise in Maruti Suzuki versus Commissioner of Central Excise, it was dealing with a situation where inputs used in generation of power, captive power plant, was used in manufacturing process as well as for supply of the power, excess power to the grid. And the question was whether this inputs, fuel, credit could be taken in respect thereof for the purposes of manufacture of the final product. This was the issue that the Supreme Court was seized with. I want you all to read para 16 of this judgment, which will give you a fair idea about what is the Supreme Court's view on functionality test. Para 16. Yeah. I'm reading it out. Read along with me. In our earlier discussion, we have referred to two considerations as irrelevant, namely use of input in the manufacturing process, be it direct or indirect, as also absence of input in the final product on account of the use of the expression used in or relation to manufacture or final product. Similarly, we are of the view that considerations such as input being used as packing material, input used as fuel, input used as generation of electricity or steam, input used as an accessory, and input used as paint are per se not relevant. All these considerations become relevant only when they are read in with the expression used in or relation to manufacture or final product in the substantive specific part of the definition. In each case, it has to be established that inputs mentioned in the inclusive part is used in and relation to manufactured final product. It is the functional utility of the item which would constitute the relevant consideration. Unless and until the said input is used in or relation to manufacture the final product within the factory, the said item would not be an eligible input. The said expression used in or relation to manufacture have many shades and would cover various situations based on the purpose for which the input is used. However, the specific input will become eligible for credit only when used in or relation to manufacture the final product. Hydrogen gas used in the manufacture of sodium cyanide is an eligible input since it has a significant role to play in the manufacturing process. So functionality test, one answer is, does it play a significant role in the manufacturing process? Does it play a significant role in the manufacturing process? If it does, then functionality test is met. I read further. Significant role to play in the manufacturing process, and since the final product cannot emerge without the use of gas. So, does it play a significant role in the manufacturing process and whether the final product can emerge without the use of that plant? If it is, then functionality test is met. Similarly, heat transfer oil used in heating medium in the manufacture of linear alkaline benzene, LAB, is an eligible input, since it has a persuasive role in the manufacturing process. So test 2, significant role is test 1, without which final product cannot emerge. Test 2 could be, does it have a persuasive role in the manufacturing process? If not significant role, does it have a persuasive role? If it is persuasive role in the manufacturing process and without its use, it is impossible to manufacture the final product. So test of impossibility. This paragraph is your sphere of the entire answer to what is functionality test. You look no further. These are the words of Supreme Court. I'm not talking about any tribunal decision or a high court decision. These are the words of Supreme Court where they have applied the functionality test and has come to the view that test whether it does play a significant role in the manufacturing process, without which the final product cannot emerge. Test whether it is a persuasive role, without which it is impossible to come out with a final product. Of course, it was rendered in the context of manufacture of goods, but it is hardly a problem to apply it to services. Because the yardsticks and considerations of impossibility, emergence of the final service or final product, final goods is not very difficult. We're not talking about a Herculean tectonic shift in application of this principle to services. Then we come to the next paragraph, para 19. As they were explaining the functionality test, they applied another thin layer, which is called the process and use test. So para 19, the question which still remains to be answered is whether an assessee would be entitled to send back credit in the cases where it sells electricity outside the factory to the joint ventures, vendors, or give it to the grid for distribution. Collector of Central Excise by Rajasthan State Chemical Mills, very important judgment. The test laid down by this court is whether the process and use are integrally connected. And at the third test, this is the process and use integration. Use of the asset concerned in the process of what you're doing, if they're integrally connected. It is another shade of whether, the process or the plant concerned plays a significant role in your process. So significant role, persuasive role, or integration of process with the use. 3 different shades of the very same genre, if I were to put it. So is whether the process and use are integrally connected. As stated above, electricity generation is more of a process having its own economics. Applying the said test, we hold that when electricity generation is a captive arrangement and the requirement is for carrying out the manufacturing activity, the electricity generation also forms part of the manufacturing activity, and the input used in the electricity generation is the input used in manufacture of final product. However, to the extent the excess electricity is cleared to the grid or distribution or to joint venture vendors, and that too for a price, the process and use test fails. In such cases, the nexus between the process and the use gets disconnected. So that's the exposition of process or process and use integration. The process and use, in this case, what happened? The process was generation of electricity. Use was sale of electricity to the grid. They had no connection with manufacture. Okay. So that's the second test that got laid down in this decision. Now, there is another attribute of this functionality test. Put up Vodafone. I'm referring to Vodafone Delhi High Court decision. And more particularly, I want to read para 5.3. Now, this judgment is under cloud because SLP was allowed, leave granted, matter heard, judgment is reserved. So whatever I'm reading out in this judgment may be short-lived or may have a long life, depending upon how, whether the Supreme Court endorses this judgment or reverses it. So put a caveat, short-lived, keep checking. Don't use it blindly. So Para 53 Delhi High Court, when elaborating what is the functional utility test. Yeah. Just one second, I think we lost the screen. Just give us a minute. Para 53. Here the Delhi High Court interprets the word functional utility in a very interesting manner. Let me read it. You follow along with me and then I'll explain. On an examination of the definition and decisions, the court is of the considered opinion that the term all goods mentioned in Rule 2K of the Safari Credit Rules would cover all goods used for providing output services, except those which are specifically excluded in the said rule. Therefore, the definition is wide enough to bring all goods which are used in providing any output service. Further, the decisions of the Supreme Court and other judgments referred to previously, the test applicable for determining whether inputs are used in manufactured goods is the functional utility test. If an item is required for providing the output services of the service provider on a commercial scale, it satisfies the functional utility test. So we have a fourth layer of what functional utility is. Look at if it is required to do it at a commercial scale. If at a commercial scale it is necessary and expedient to use that plant, then it is a plant. It meets the functionality test. What I'm trying to tell you is that when you make your position on the attribute of whether it is a plant, make sure that you slash all the T's and dot all the I's using all these four tests. Don't go bare bone by saying that it meets one of the tests or one of the litmus for qualification for the functional utility test. Apply the litmus on all four counts that I just explained to you. Integrally used, persuasive, then this process and use, integrally connection. Fourth is commercial scale. Should you pass all these four, then I think you're home. Okay, I read this paragraph further. If an item is required for providing the output service of the service provider on a commercial scale, it satisfies the functional utility test. In the facts of the present case, what emerges is the BTS is an integrated system and each of its components have to work in tandem with each other in order to provide the required connectivity for cellular phones, user, and for efficient telecom services. The towers and prefabricated shelters form an essential in the provision of the telecom services. The CSTAT, in the opinion of this court, failed to appreciate that it is well settled that the work used should be understood in a wide sense so as to include passive as well as active use. The towers in CKD condition are used for the purpose of supplying the service and therefore would qualify as inputs. There is actual usage of the tower and shelter in conjunction with the antenna and BTS equipment in providing the output services, and then etc. etc. Now let's read the last line, which clearly rule that towers and shelters are indeed used and are integrally connected to the rendition of telecom services. So integral connection, process and use test. So the long and short of it, to meet the functionality test, look at your facts and try to fit yourself into any of these four, and certainly all four. I wouldn't say any of these, all four. Okay. To reiterate, what are those four for everybody's benefit? Once again, look at whether it plays a significant role without which production is not possible or rendition is not possible. Look at whether it plays a persuasive role without which it is impossible to carry out the manufacturing process or provision of services. Look at the process and use and find out whether the process and use are integrally connected or disconnected. And last, look at whether on a commercial scale thing can be done without this, which is the Delhi High Court interpretation of functional utility. Okay. There is a fifth filter I want to add for abundant caution, which I call the commercial expediency test, which has its thread with the principle discussed in the Delhi High Court in Vodafone. But there is a greater jurisprudence attached to that, which the Delhi High Court has not dealt with, may not be the occasion, need not arise, but it kind of snugs well with the commercial scale logic. The principle is, if an activity is theoretically possible without the use of something, but economically not feasible without the use of that, then the commercial expediency test fails. Meaning thereby, you can manufacture ice in your fridge, right? But can you manufacture ice in your fridge and start selling at the nearest shop? So commercial expediency fails. At a commercial level, you can't do it. Otherwise, you would have had Central Excise officers coming to your house and saying, please pay excise duty on manufacture of ice, right? So the process of freezing of water leading to creation of ice is not at a commercial scale, right? But the same fellow sets up a chiller to make 100 tons of ice every day or whatever. Then for the commercial expediency of that, the chiller becomes very important, right? That's the commercial expediency. That something is not possible commercially unless something is put in for the scale and size that you want to achieve. That's the commercial expediency test. A classic example of that I always keep giving whenever I talk about this. If you go back to the Central Sales Tax Act, you could purchase goods at a concessional rate under Form C, provided you use the goods for manufacture, generation of power, packing, mining, or resale, right? Form C could be used for any one of them. So there was a case where a power generating company had purchased gloves and raincoats, which had to be worn by the linesmen who would stand outside the generating building, and they would examine whether the line that is connecting the generating station to the grid are properly maintained or not. Okay, so those gloves and the uniform was being worn by linesmen who were standing outside the building. Clearly, revenue said, we are not going to allow you purchase of these gloves and uniform against Form C because this has no connection whatsoever with generation of power. Neither it is an input as a fuel, nor did you sit there and generate. None of these things. There was no nexus whatsoever. Without these plants, without these gloves and raincoat, generation was not impossible. Correct? So it would have met the impossibility. It would not have met, it would have passed the impossibility test saying that, no, generation is possible without this. It is not impossible to generate without these gloves. Supreme Court coined another test saying that, yes, theoretically, generation is possible. But from a commercial point of view, these gloves and jackets or raincoats are necessary because the linesman would wear it, stand outside in the middle of the night during rains, and make sure that there is no leakage in the line of carrying the electricity from the bus bar to the grid. Their job is to make sure that does not happen. Therefore, they need it. Because the nature of business is such that transmission loss of this kind should be avoided, because electricity cannot be stored. As soon as it gets generated, it gets evacuated. So therefore, these people are necessary because it is commercially inexpedient, economically not feasible for generation of power at a large scale without the help of these linesmen. So it was a case which is one step removed from the actual usage of process and use test. One step removed from the integral nexus stage or the impossibility of manufacture stage. And there commercial expediency was brought in. My point is, just because Supreme Court has mentioned functionality test does not mean we should rest there. functionality test is a guidance point, a start point, but it cannot be the end point either. Because the whole issue is now up for debate before the revenue authorities and the high courts later on, right? If we are able to satisfy them on functionality test, process and use test, and also why can't we use the commercial expediency test also? Because different businesses will have different dynamics of facts. What applies to a mall, what applies to a warehouse, what applies to a manufacturer, what applies to a cold storage fellow. It could be, the business drivers could be entirely different. So let us not, the moral of the story I'm saying, let us not rest our argument, rest our thought process only at the functional utility test, but also extend to process and use test and to the commercial expediency test also. And let's test it. Because commercial expediency test has got the endorsement of the Supreme Court. The judgment I'm talking about is Rajasthan State Electricity Board judgment. And that is based on another judgment of Supreme Court, East India Cotton Manufacturing. There's a hordes of precedents on that, and there's no reason why the Supreme Court ought not to be persuaded, because now it has become a virgin territory, this functional utility as a concept. It is not that the Supreme Court has legislated, it has left it. Depending upon the facts of each case, it will have to be arbitrated, right? So that's my point on the plant business. The next test, what they are also saying, that if a building has been planned and constructed as to serve as assessee's special technical requirement, it will qualify as a plant. Now, special technical requirement was a word that was used in Karnataka Power Corporation. It is not something that in Safari Supreme Court coined it. And special technical requirement was a function of the actual process that was involved in power generation, because in power generation, all these ducts and etc. are all integrally connected. So if you think that the tax officer is going to ask, give me your technical report, that's not what the intention is. Well, they can ask whatever they want to, because it is their satisfaction, because adjudicating authorities, we can't tell them what they should not ask or what they should ask. But should they ask? Our responsibility would be to say, technical specification has to be understood to mean the technical process involved in delivery of the services. It is more relevant for manufacture because, or generation of power, because it has all kinds of, input, output, outlet, chain, rollers, cranes, and the whole thing, the whole product goes through multiple layers before the final product comes out. But in a service, the technical specification would not be that complicated. And what kind of technical specification that we can give to the tax authorities concerned will depend on what kind of output services we are talking about. I mean, tell you in the example of telecom services that I just read out from Vodafone, it's very simple. How can I relay the signal without a tower? I'm not going to carry a torch with the signal and run from Bazaar A to Bazaar B so that it can't happen, right? That the whole purpose of mobile phone is that the signals are all over, right? Without the signals being moving around, impossible to render a telecom services of this kind. So therefore, it is in technical process is so integrated. You can use that. But in a cold storage, you can use it. How do I have a cold storage without having chiller plant, without having AC of this control, that control, humidification? That's all just pure simple logic. But it is not that you'll have to get into explain the technical process bit by bit. I mean, if you do that, great. But I don't think that is warranted. That would be hair splitting beyond any relevance. So the next test, apart from this functional utility test, or part of the functional utility test, is look at whether what has been constructed is constructed to serve an assessee's special technical requirement. Okay. Then they say that plant under 17.5D cannot be given a restrictive meaning as appearing in the explanation. So we're not giving with that. Okay. Now we come to the word machinery, because the word is plant or machinery, right? Now machinery can also be movable, immovable, right? Machinery A plant is a genus. Machinery is a subset of that. Both can be immovable, both can be movable. Machinery by definition means machinery by definition means something that has a mechanical motion. That is machine. Machine is something that has a mechanical motion. And it works in tandem with various other components for moving force or converting force. Okay, for moving force, for converting force. I want you to read this judgment, CIT versus Mir Muhammad, para 13. I'll just put it up. I just saw somebody put a question, what about administrative building? I will come to that a little while from now. So para 13, Supreme Court explains the meaning of machine in CIT versus Mir Muhammad. What then is the test for determining whether a mechanical contrivance is machinery for the purpose of second para of clause 6 and clause 7a? The Privy Council in the case of Corporation of Calcutta versus Chairman Kashipur and Chitpur municipality hazarded the following definition of machinery. The word machinery, when used in ordinary language, prima facie means some mechanical contrivance which by themselves or in combination with one or more other mechanical contrivance, by the combined movement and interdependent operation of the respective parts, generate power or evoke, modify, apply, or direct natural force with the object in each case of effecting so definite and a specific result. They had already observed the word machinery must mean more than a collection of ordinary tools. The Privy Council Privy Council case was not a tax case, but prima facie, the ordinary meaning of the word machine and the word machinery is an ordinary and not technical word, must, unless there is something in the context, prevail in the Indian income tax also. So this principle that is there in Mir Muhammad can be applied with all force for Safari purposes also. Because the ordinary meaning was read into income tax, there is no reason why this should not be read into Safari as well. Which means combination of various components mechanically attached moving force. That is not very difficult to establish because every operation will have its mechanical assets that are deployed, and it is only that will qualify. Okay. So to summarize, plant or machinery for 17.5D is not for understanding that you don't have to go. Plant for 17.5D, you don't have to go to the explanation. To understand if you're plant or not, the functional utilities test is what you will apply. All those 4 elements that I mentioned, you go take the test through that. And if you pass all of that, you have nothing to worry at all. You are straight away into section 16. And machinery is something that I just read out from this judgment. You can use that as a good guidance point to figure out whether it is a machine or not. Assuming for a moment, and this is where the question that was just posed to me, administrative building, becomes relevant. Assume for a moment, a certain building does not meet the test of plant. And can somebody go mute? Yeah. Assume for a moment a given building does not fit the definition of plant. Case in hand could actually be an administrative building. Because if I apply the test of Maruti Suzuki judgment, it probably the production of the final product may have nothing to do with the plant, nothing to do with the administrative building. Okay. It has nothing to do with that. It is neither a case where it is integrally connected, nor can the process and test be said to be so that without this administrative building, your production was not possible. It did not play any persuasive role either, neither direct nor persuasive role as in active or tacit role. Without which the production was impossible, because the same administrative building you could have operated from hotel. You choose not to do that. So, at the risk of not being very popular in my statement here, perhaps administrative building will not qualify. Because in all probability, it will not pass the muster of functional utility, commercial expediency, and all of those things. Because there's an alternative available to you. You may choose not to do that, but there's an alternative available. But hang on. Just because it does not fit the bill of a plant, all is not dead. We then come to the third test, as I mentioned at the beginning. First test was, if it is not immutable property, you have nothing to worry. If it is immutable property and it is plant, meet the test of plant. If you do not meet the test of plant, then you see whether it is on own account or not. And how the problem will get solved when we go to the own account aspect. The way own account has been interpreted by the Supreme Court is strange, but I am not complaining. Supreme Court says that if it is not for own account, then credit will be available to you, right? If it is not for own account, then credit will be available to you. Which means if the administrative building, which does not fit the meaning of the word plant, credit can be claimed only if the construction was not own account. Own account, Supreme Court reads, rightly or wrongly, but that is the law. Own account, Supreme Court reads to mean if it is purchased for self-consumption, right? Which is personal usage. Now, administrative building will certainly not be something that has been procured for personal usage. So it will still meet the test of not on own account. Second, it is to be used by a person constructing as a setting in which business is carried out. Problematic. Because indeed, this administrative building is a place or a setting in which business has been carried out. And the only exception, Supreme Court says, it will not be treated as own account if it is intended for lease. So maybe better off, don't get your administrative building constructed and owned. Get it constructed and take it on lease. You hear what I'm saying? Instead of building the administrative building yourself, such that the administrative building fits the bill of being a setting from which business is carried out, and also does not qualify as a plant, move out of that, break it down, rebuild it, get it on lease. Because if it is on lease, then it doesn't fall foul of the on account thing. Then it comes out of on account. It becomes not on own account. So very weird, but that is the law. There is an opportunity. So, on the attribute of not on own account versus own account is something that is for personal usage. Own account is something that is used as a setting from where business is carried out. Own account, it will not be on own account if it is leased out and if it is sold. But we're not concerned with sale, because the moment you have a sale, there is no output GST, there is no question of credit. So ignore that word sale that he may have used, the judge may have used. The relevant part is lease. If it is leased, then there is no question of own account, in which case you can claim the credit. Therefore, to summarize, so far as 17.5D is concerned, lots of questions are coming in, while it is distracting me a bit, but I'll deal with them later on, okay, because the questions are popping up and that's distracting me. Nonetheless, the summary of 17.5D put in a simple line or two, such that even a layman understands, is as follows. You don't look at 17.5D if what has been constructed is a movable property as understood in common law. Two, you don't look into 17.5D restriction if what has been constructed, even though an immovable property, but qualifies as a plant. And to qualify as a plant, ordinarily commercial parlance plus functional utility and process and use test and commercial expediency. Use all of these that are available as a tool and go back to the revenue. C, if you don't pass the test of movable property, if you don't pass the test of plant, then try and see if you can pass the test of not on own account, because if it is not on own account, you get the credit. And to qualify as not on own account, all you have to show is that you are not using it for personal consumption, or all you have to show is that it is not a setting from where business is carried out. If it is a setting from which business is carried out, then restructure it, take it on lease, because supply on lease, Supreme Court says, is not own account, not on own account. That is the summation of what 17.5D universe is all about. Now, the problem doesn't end here. Unless we understand how does it interplay with 17.5C, this discussion is meaningless. Unfortunately, the learned judges have not given any serious consideration to interpreting 17.5C. It has come to a situation where, as if the only purpose of 17.5C and D discussion was the validity part. We are therefore faced with a situation as obtained from the judgment, that while I can have a peaceful sleep under 17.5D, but the revenue will not leave you, trust me, just by looking at 17.5D, because you still have to cross the barrier of 17.5C. Because 16.1 is subject to non-obstant 17.5, all of it. And if you fall under 17.5C, even if you fall out of 17.5D, you have no hope in life, because 17.5C is a restriction. So we will have to put some meaning to the words or restrictions in 17.5C to understand under what circumstances 17.5C really apply and under what circumstances 17.5D applies. Unless you have done that restructuring or reorientation, it may not yield much result. I do not know how 17.5C has been, and C and D has been read in tandem by other speakers across the country, or all of you who are sitting here. But I have attempted to reconcile the two and try to come out with some thoughts. In my personal opinion, as obtained from the judgment of Safari, insofar as the interpretation of 17.5D is concerned, it now appears that the scope of 17.5C restriction applies only to a contractor and not to a project owner. Restriction of 17.5D applies to a project owner, the end user. Because it is in that context they use the word on own account. Whereas restriction on 17.5C applies to a contractor, not a project owner. And this logic comes out also clear because when you see 17.5C, the exception is except where it is used for further works contract. Right? 17.5C says except where it is used for further works contract. There's an exception. Anshika, can you just put up the provision 17.5C so that we are able to come to page PDF page 46 so that I am able to explain to them. C says works contract services when supplied for construction of an immovable property other than plant and machinery, except where it is an input service for further supply works contract. Therefore, from the tenor of 17.5C, it appears that 17.5C applies or does not apply to an end customer, project owner. Instead, it applies to a contractor or a person who has the status of a contractor, because it is in his case that the exception will become relevant. If that contractor is doing a further works contract, 17.5C does not trigger at all. And this ability to do a further supply works contract services can never be triggered in the context of a project owner or an end user. This is my reading of a harmonious reading of the meaning of 17.5D and 17.5C as obtained from the judgment of Safari. What does therefore mean? What kind of contractor are we talking about? Because every contractor, at what level are we talking about? The ITC. What level? What's the restriction? So, 17.5D restriction on claiming credit applies to the project owner because it uses the word receives. Goods or services are both received by a taxable person. So it's in the hands of the recipient project owner what restrictions apply in what he is doing. Whereas 17.5C does not use the word received, it uses the word supplies. When works contract services when supplied for construction of real property. So the test that will have to be applied is the supplier side in 17.5C. In 17.5D, the test has to be applied at the recipient side. Only then it reconciles. Otherwise, 17.5C becomes otious, meaningless. Right? So, my reading is 17.5C applies to a contractor who does not do a further supply of works contract services. Right? And what he has created is indisputably a building. Now you'll ask me what cases gets covered. Because the works contractor output will always be a works contract services, is it not? So 100% of the case he should be outside. I could think of one case where he will not be outside. That is based on the decision of Supreme Court in L&T in a flat buyer's agreement. In a flat buyer's agreement, Supreme Court took a view that a promoter who enters into a flat buyer agreement is a contractor. Because the earlier view was all of those builders who sell flats, they are not contractors, right? They are selling immovable property. They are end users themselves. Supreme Court said, no, sorry, you did not. You're not, because you have a pre-existing flat buyer's agreement pursuant to which you carried out the execution of the construction. Therefore, Your status is not of a developer. Your status is of a contractor. So such of those builders who has entered into a flat buyer's agreement in respect of which the construction has been carried out by him, he will be said to be carrying out works contract services if he has an existing flat buyer's agreement under which the construction has happened. But he did not have any existing works contract agreement or flat buyer's agreement. Even though he's a contractor, but for want of doing a works contract services, instead he's doing a sale of immoral property or sale of flat, he is hit by 17(5)(c) for the right reason. Because what he's selling is sale of land or sale of building. After CC, before CC, therefore becomes very relevant. If the whole consideration is received after CC, then it's not a works contract service. It will not qualify as a construction services. So my rough and ready reconciliation between 17(5)(c) and D is 17(5)(c) probably is now restricted only to a flat buyer agreement kind of situation or a contractor. And you test it at the supplier side, the contractor side, that ITC restriction has to be looked at the contractor side or what he's doing with that. Whereas 17(5)(d), the test is going to be at the end customer side, end user side, what he's doing with it. If we look at it in that point approach, then I think it can be reconciled very well. Therefore, my suggestion to all of you all is that there is hope. There is hope to rekindle this whole credit issue and go back to the drawing board by appreciating each transactional fact and developing an argument using Safari as your backbone. And don't rest yourself only on Safari. There are enough jurisprudence. If the Supreme Court could have applied income tax judgment on plant and machinery, then there is no reason for us to stop there. And I keep on saying, do not make the judgments referred to by Supreme Court in Safari as the be-all and end-all. Exponentially develop it and use other arsenal if you can, borrowed from other income tax judgments if you will, or excise service tax or whatever, and bolster your point of view. Okay. With that, I will stop. I don't know how much time I have. I just want to take through the questions that are there. So can somebody just read out the questions for my benefit? Arup, I can't hear you. You are, I think, on mute or volume is low.
Yes, am I audible now?
Yeah.
Yeah. So on a lighter note, I just wanted to share that when leaving for this session today from my home, my daughter was saying, "Why do you have to study so much?" So while going through your last 5 minutes, I was just wondering, for the last 7 years, I was wondering what is the difference between 17(5)(c) and D. And today, through your deliberation, when you took us through this part of when supplied and received, I could actually get through this distinction. So I'm just surprised that, even after 7 years, such small things have been brought out. And it really feels that I'm really grateful on behalf of entire members, all the members of CGPI, for bringing to us such finer points. And so I'll now quickly go through the questions. So, yeah. So the first question is, administrative building, you have already answered. So again, based on functionality test, can we claim credit on construction of factory buildings?
So answer is very clear. It will not qualify as a plant unless the functionality test is met. Chances of that meeting is very difficult unless the factory is so designed, peculiar technical specifications that it uses vacuum, this, that, etc. Otherwise, it's a shed. Chances of that meeting may not be there. And even then, it will not be on own account because it will qualify as own account because it's a setting from where the production happens, unless we are able to show that no, it had a necessary nexus. That's why Supreme Court didn't want to come out with a carte blanche statement, and therefore every transaction will have to be looked at. But they become suspect.
So the next question is about that the SC has actually remanded the matter for factual inquiry to the different high courts. So what do you think about the finality? Has it received any finality?
High Court will turn it back, send it back. If the Supreme Court is not looking at facts, why should the High Court look at it? They'll say you all the writ petitions are dismissed. You go and appear before your tax authorities and raise your issues before them. Come back after adjudication through a normal appeal.
Okay, so that's again a thing not to be too cheerful about. So the next is warehouses and offices are generally constructed without any technical specification of tenant in such case. What's your view for claim?
No. So I think people are getting misreading technical specifications to mean you have to show the drawing, designs, etc. Sorry, that's what I try to clear. It is a offshoot of the functional utility test of how is it integrally connected with your outside. That's what it is. You don't have to come up with the drawings and plans and give it all of that to the tax office. I don't think that's what they're looking at.
Right. So, and also the sanction plan will squarely show that it's a commercial property.
Again, sanction plan is also not necessary unless those are supportive evidence to the substantive point of integral nexus.
Yes.
Build that and use those as your support, but don't show the design and drawing and approval plans, all of that. That will not take you anywhere.
Right. So another is like, again about hotels. I think hotels are carte blanche, they are not allowed. So
very strange. And like I said, and I'm criticizing the Supreme Court on this point, there is no reason just because in Karnataka Power Corporation, they said, okay, Anand Theatre may be right in that is concerned. Here we are not concerned. In Safari, they have reconciled that too, saying that, okay, that is also not there. This is also there. This is not deliberation. I'm sorry.
Because for hotels and theaters, I think they're more kind of a plant. Like,
well, that's the problem. So now they're not even plant, huh?
Yes, they're not even plant. So then again, if we plant, so the next question is, we construct shed or warehouse and give it on lease or rental. So do we get that?
You will get it now. So the whole leasing industry should be very happy, yeah?
Yes. And in fact, structuring will now do a,
like I said,
very important
administrative building. You get it on lease, you'll get the credit. Everybody gets the credit. Structure it.
Okay, so next question I would not like to take, but yeah, we can do that. That whether GST is payable on under construction property. So can we advance the argument that as stamp duty is paid on the immovable property, that GST is not payable on under construction property?
Please read the judgment of Supreme Court in L&T with the flat buyer's agreement. You will have an answer. It is payable. If the under constructed activity, the agreement exists, basis which you are constructing, then you are a contractor. You're not a developer or a builder. You're not selling immovable property. Only the value of land will get excluded from the computation of GST liability. Otherwise, it's a taxable supply. That's the concept. Then this pre-CC, post-CC is what they have in GST, they have brought out the distinction.
Artificially created.
Yeah. So conceptually, it's a contractor.
The next is what if works contract service has been used for construction of plant, for own plant. So that
works contract services has been used only in 17.5C. It has not been used in 75D. 17.5C, like I said, works contract services is the genre of services leading to creation of an immovable property other than plant or machinery as explained. It is
and I think sir, one key takeaway from today's session, which I'll more ponder upon, as I get time, is to define this distinction between 17.5C and D as you have shared. I think that's a very important thing that is been dealt with. And and para 65C, okay. If we constructed a hotel for renting, can we take input? So we are constructing a hotel and then giving it on lease.
You can't say that you have constructed a hotel then. You have constructed a building which is capable of being used as a hotel. Then you have leased it. That's fine.
So since it's again a leasing, so I get back to that ITC that.
The whole hotel industry will start, self-construction will become leasing. So leasing business will boom now.
Yeah. So next question is that if I avail input service of works contract service for providing output service of construction services, recognizes commercial construction. So can the works contract service ITC be restricted to 17.5C? Okay, Vaibhavji, I think we need to clarify the question. Most probably it is being dealt with in other theatres, which sir has already dealt. So next is very important. Yeah, again, this is again a key question which is being pondered about, which is prefabricated building. What will be the status of prefabricated buildings?
Help me understand the facts.
So say Tata Blue Scope is giving me prefabricated structures with which I construct the building within 1 or 2 days. So everything is ready. The walls are ready. The roofs are ready. So and the HSN of the same is also on goods. So the service element involved in that is only to the scale of installation of the building. It's not construction.
Can we not take the position that those prefabs
Yes.
or which are in the nature of movable property? And if it is movable property, then you never were subject to 17.5C or D.
Right.
Because the idea is not to have any permanency, no?
Yeah.
Like in Delhi and many other places where there is a temporary permanent structures cannot be created for regulations. You create those pota cables, prefabs. So you are able to use it for the same purpose, but there is no permanency attached because tomorrow you can move it out without creating disturbance to the earth or damage.
So here, as you have rightly said, so we just when we go through the test of immovable property, we don't pass that. So because of that, we are the ITC.
You were never in the 17.5C or D to begin with.
Yeah. So next question is solid engineering case and other precedents cited dealt with the levy of tax on outward transactions, whereas 17.5 pertains to input transactions. So
no, that's not relevant. I think the person who has asked this question has not got the point. Solid and contrary is to figure out what is movable, what is immovable. That's all. That is the test for movability, immovability. If you meet the test and therefore qualify as movable, then you don't look at 17.5C or D at all. Because 17.5C and D, the precondition is immovable property.
Right. Again, another question is that whether as 17.5D uses the phrase where such goods or services both are used in the course of furtherance of business. So if other than business, if I'm using it, will it get restricted? So I think that is answered through
that's
the
personal. That's the personal usage, no? That's the
Yeah.
personal usage that he says.
Right. Okay. One own account, sir, has already shared. Okay. A difference. What would be the difference? If you could share again the difference between scalability from commercial angle and commercial expediency, the fourth layer and the fifth layer that you shared. Sir.
So both are indicative of the importance of the plant or the process with the objective of making it viable, making the business operation viable. Scalability is a way of saying that growth in my business, no?
Yes.
Commercial expediency is all about that because I have to stay in business. Therefore, scalability is an inherent part of commercial expediency in that sense, no?
Right. So we'll take 2 to 3 more questions, sir. I think if it's okay with you. So now comes a very important question, actually, which is again raised in many circles, which is if I've already availed the credit, so what should be my stand on that right now?
No, so this is
based on the judgment.
This is a problematic thing. There are two kinds of assessees that I'm aware of. One who could not claim the credit or who did not claim the credit. One who claimed the credit, knowing fully well at that time that credit was never available to him. Is it not?
Right.
You can't say that 10 years back or 3 years back or 5 years back, you knew how Safari will get interpreted. Therefore, I claimed it. You are outright not eligible perhaps based on some interpretation. So we'll divide it into two categories. If you claim the credit under 17.5C, obviously the assumption is you have not utilized it, right? Because you're not sure, because if you utilize it, then you have a problem. You know, if it were wrongly utilized, penalty, penalty, interest, all those things come in, right? Such cases, if you believe that you actually fall under 17.5D and not 17.5C, then nothing stops you from saying that my claim under 17.5C should be deemed as a 17.5D. Mentioning of a wrong, just as mentioning of a wrong section in a show cause notice does not vitiate the show cause notice. Similarly, mentioning of the wrong entry in my return should not vitiate my claim so long as the source is available to me, which is 17.5D. At best, it can be a technical or venial breach, which should not take us too much. Okay, because what really matters is, am I covered under 17.5D or not? Did I file a claim, albeit under the wrong head? Was I under limitations, covered by limitation? If all those things are there, mere mentioning of a wrong should not bother you. And my problem is with respect to those who never claimed it. How do you take that benefit today? How do you take that benefit? Your returns are all gone. Limitation period was long over, subject to the now amendment that has happened, right? So it requires discussion on that point for those who have not claimed it. And I don't know why in this batch of writ petitions, they challenge 16.4, that clause has also been said to be valid compared to 16.1 or whatever, that last paragraph, right? Time limit for claiming credit, they validated it. I don't know why did anybody want to argue that?
Any questions are common, so we are just clubbing them. If a commercial property is leased, can we directly say that it's a tool without which we cannot render service? I think that is already answered. At what point of time intention one should have one? So the question is that at what point of time intention of own account should be considered? So I had actually constructed a property for the purpose of business, but later on I converted to own office or own usage. So in that case, what do we do?
See, the word used is not intended. The word used is not intended for his own account. The word used is at the present when the credit is being taken.
Right.
Unlike 16.1, which says credit can be taken for use or intended to be used for furtherance of business, right? Which means if you, so long as you intended at a later point in time, etc., here the width is not there perhaps. So it will have to be tested at that threshold when the credit comes on your lap.
Right. So, and so one final question is, one final question, sir, is that will the entry in my books of accounts really matter? Why, as far as this availing of credit is allowed?
I don't see that. Books of account reflects the state of affairs, right?
Right.
Of whether you are, it's a capital asset in your books, whether it's an inventory in your books, all those things, right? But books of account will not deal with you whether it's a functional utility test or not. For income tax debt purposes, you will certainly take it as a plant unless it's an inventory in your hand, right?
Right. So,
and if it is a plant for income tax purposes and it has been tested, income tax decisions have held it to be income tax, it's a plant, then it becomes that much easier for safari purposes. So your depreciation related claims or ATIA related claims, all those under income tax which has some nexus with whether it is a plant or not, bring it on. Bring it now, because now it's the season of income tax into safari.
So before we close, one final question.
Anup, can't hear you. Your voice didn't travel.
Maybe you can mute him. I do not mute him.
Hope you can't be heard.
Am I audible also?
Yeah.
Yes.
Yeah. So one final question, sir, before just we conclude that, as you have rightly shared, that maybe the joy will be short-lived and not long-lived if there is a change to, as per the doctrine of errors that we have mentioned. So considering that, what should be the stand that we take in the future? Like
No. So don't wait for that to happen. Assume that's doctrine of minor repairs. So small repairs is not to be invoked. Retrospective amendment they will not do.
Okay.
On the basis, until it is done, why do you have to assume that they will do a... No. You take your position. You now start assuming that there is no end. It is the beginning. Safari has given you a ray of hope. Use it and march on. Should something
Thank you, sir.
happen, we'll see it at that stage. Yeah.
Yes. Thank you so much, sir, for your time. I think it was really enlightening session for all of us. And we still have around 20 questions, but time is a restriction and some of them are common. So thanks to all the participants for joining in. I would request Nitin Bhuta, sir, to offer a vote of thanks to sir.
Good afternoon to all our esteemed participants of the webinar. When my close friends who are renowned GST professionals and I founded CGPI, I could visualize that this will be a forum where luminaries in the practice of indirect taxation will actively associate to build a platform of excellence, a platform where deliberations on intricate, controversial and challenging topics will be held and knowledgeable dissemination to benefit large cross-sections of the stakeholders. Sujit Sir, rendition today is excellence personified in true tradition of our forum. Sir's concepts of various tests to be applied considering the Safari judgments, doctrine of small repairs, de jure versus de facto, and masterfully crafted exposition as would have helped all the participants to understand and take away a lot of value insights. Sir, it is my privilege to express a very well-deserved vote of thanks to you for dwelling at length in a very analytical manner on the nuances of the topic. You have addressed the issues objectively and covered the technicalities which really matters to the participants, especially the functionality test, commercial parlance. On behalf of CGPI and also personally, I earnestly thank you for sparing your valuable time to address us today. Thank you, sir. Please accept our deepest gratitude. Thank you.
Thank you. It was my pleasure.
Thank you very much, sir. Thank you. And thanks to all the participants for joining in from. And sir, just to share with you, we have participants across India, right from Assam to Tripura, to West Bengal, to Bihar, to Odisha, to Maharashtra, Gujarat, Tamil Nadu, Kerala, everywhere. People from
Yeah, it's heartening to see that after 1.5 hours or whatever, we still have 111 people still in the web room, which is like quite a good,
so around 212 unique people joined, participants joined, and more than 170 plus they were throughout the session they were there. So that itself shows the depth of like the discussion that we had. And thank you once again for sparing your time on a Sunday morning rather.
Thank you.
Thank you very much. And
Okay.
thanks to all the participants.
Thank you.
Thank you very much, sir. Thank you.
And thanks to all our core committee members for the behind the scenes. Thank you very much.
Thank you, sir. Thank you.